My name is Dean Reuter. I am the Senior Vice President and General Counsel of the Federalist Society. It's my honor and... Go ahead, Don. That's for the Federalist Society. It's my honor and privilege to introduce our luncheon speaker. But first I want to thank you all for being here in the room and on the live stream, or watching us on video later. And I want to thank Bob Eitel and his team at DFI. They really are in charge of the conceptual framework of today's conference. They've done a great job. And I've learned a lot already this morning, and I always look forward to hearing from the Honorable Eugene Scalia. And I do like to call him the Honorable Eugene Scalia, which reminds me of a story, of course. I like to tell stories, but this story relates to one of my former Federalist Society colleagues who was very formal, would always refer to professors as Professor so-and-so or whatever. And he was, at the time, 45 years old, so he wasn't a kid. Jim Lindgren is a Northwestern Law School professor, probably known to a lot of you. And David, my colleague, would say, Professor Lindgren, have we thought about this? Or Professor Lindgren, could I get you to do this? Professor Lindgren this, Professor Lindgren that. Finally, Jim said to David, he said, David, we've known each other for decades. Please, call me Mr. Lindgren. So I thought that was humorous, but I like the formal title. So again, my distinct pleasure and honor to introduce the Honorable Eugene Scalia. I will very briefly give you some background on him so we can reserve time for his talk, and then he's going to take questions. Of course, you know him as the former Secretary of the United States Department of Labor. His education began at the University of Virginia, where he graduated with distinction, went on to the University of Chicago Law School, where he graduated cum laude, and editor-in-chief of the Law Review. He served, I had forgotten this actually, and he reminded me of it last night. He served as a speechwriter and served in the U.S. Department of Education as a speechwriter and other duties to William J. Bennett back in the day, so he knows whereof he speaks. And then from 92 to 93, he served as special assistant to Attorney General William Barr. He served as Solicitor of Labor some time ago, back in the early 2000s. Between all of these government positions, he's been at Gibson, Dunn, where he's developed expertise in labor and employment law in particular, but also administrative and regulatory law. He's been in private practice there off and on, and where he is now. And now he leads Gibson Dunn's ad law and regulatory practice group. But he still works with the Labor and Employment and Financial Institutions practice group at that firm. Importantly, he's been a Federalist Society leader for his entire career, I would guess, but for as long as I've been there, which is at least 25 years. So thank you for being here, and please join me in welcoming the Honorable Eugene Scalia.
Thank you, Dean, for the introduction. Thank you for reminding everybody several times that I am honorable. I didn't need a lot of that kind of stuff when I was secretary, but coming home, having my 7-year-old daughter call me Mr. Secretary, I love that. I got to get her to start that again. Well, it's really nice to join all of you, to join the Federalist Society, and also to join DFI. And Bob and his wife, Nan, are actually old friends, and it's wonderful to see the work that they're engaged in, and wonderful to join other old friends here too. It's also a treat to speak at a conference focused on two topics, education and the workforce, that overlap in so many important ways. This overlap was one of the most interesting and actually heartening areas that I dealt with as labor secretary. There are a lot of things to disagree about when it comes to labor and employment policy. But a welcome area of agreement recently has been the role that can be played by apprenticeships and other so-called work-based learning programs. As many of you know, apprenticeship has been a principal route to successful careers for young people in Germany, Switzerland, and elsewhere for centuries. There are leading executives in Europe whose entry into the workforce was not after college, but as apprentices. And that's not just in manufacturing, it's in financial services, for example. As secretary, I saw growing appreciation for apprenticeship on the part of businesses, community colleges, high schools, and policymakers. Many different encounters, meetings that I remember. A visit to an advanced manufacturing plant in North Carolina where I met a young man. He was probably about 21 or 22. He'd excelled in high school, but told his teachers and guidance counselor, I don't want to go to college. I like to work with my hands. I want to make things. I want to go into this apprenticeship program. They were beside themselves, but he did it. And there we were, I don't know, 3 or 4 years later. He had a very good paid job with this manufacturing company, and he had been able to buy a house. He might have been 22. In Michigan, I met the controller of a manufacturer who had started there right after high school, no college, but she used their tuition reimbursement program to get a degree in accounting. And after getting the degree, switched over into their finance function, and 15 years later, she was their controller. In Tennessee, I visited a community college that was working very closely with local businesses to determine what technical skills they needed at that moment and expected to need down the road, and then they were tailoring courses to exactly that set of skills, enabling young people to come out of high school, or sometimes a couple years after high school, get those skills, and again, step into what were good-paying manufacturing jobs. And then, as some of you know, there's a huge interest right now in offering and obtaining credentials that reflect mastery of a particular skill, like computer coding, that can be immensely valuable, but which just plainly doesn't require 4 years of college. These trends and the opportunities they offer young people were among the most encouraging things I saw as labor secretary. There was great energy and enthusiasm behind them. And to a large extent, not entirely, there was bipartisan consensus. There was also consensus that we as a country have been overvaluing college and not properly acknowledging the contributions and value of non-professional, non-white collar jobs. Of course, there's a downside to this growing appreciation for work-based learning, and that's that it stems in part from Americans' frustration with the performance of our formal education system, K through 12 and colleges and universities. The travails of our education system are long-standing, and they take me back to my first job in government long ago, which Dean mentioned. After graduating college, I had the good fortune, as you heard, to land a job as a speechwriter for Education Secretary William Bennett. I'm forever grateful for that job, for Bill Bennett's example and friendship, and for other friends I made there and things I learned in those years. Bill's brother Bob died yesterday. I saw Bob Bennett was another just extraordinary person, and different than his brother in some ways, but just also larger than life. Quick story, he was part of a poker game that used to be played at, it rotated, but often at my parents' house. And Chief Justice Rehnquist was part of the game. Bob Bennett, as I mentioned. Leonard Garment. Don, was he one of your predecessors as White House counsel? He's anyway, very distinguished Washington lawyer. One of my little brothers came down, saw this going on, and said to my mother, "Mommy, is this legal?" She assured it was going to be okay. So Bennett called his priorities the 3 C's: content, character, and choice. By content, he meant there are certain things so great and fundamental that all schools should teach them. Quote, the best which has been thought and written, or no, thought and said, Bennett would say, quoting Matthew Arnold. Character, the second C, was the conviction that school's job was to transmit certain virtues, to, for example, unflinchingly instruct students in honesty, self-discipline, loyalty, and other qualities that Bennett later celebrated in his Book of Virtues. The third C was school choice. At the education department, I quickly learned that the teachers' unions didn't like the third C. Their opposition to school choice and to Bennett himself was vehement. That was partly because Bennett liked a good fight. As his speechwriters, we had standing instructions to use stories from great works of literature. For a speech about education reformers who had become co-opted by the education bureaucracy, I started a speech with a story about the shipmates from the Odyssey who went native in the land of the lotus eaters. Bill liked that, and I still remember one of the targets of that criticism, they said in response, "We are not lotus eaters." We had never intended the criticism so literally. Bennett once instructed me to write a speech comparing the education bureaucracy to another jewel of Western civilization, the 1958 movie, The Blob. I wouldn't have come up with that cultural reference on my own. Fresh out of college, I wasn't surprised that the Union of Workers at public schools opposed increased competition from private schools. Unions typically oppose practices that divert work away from them. What was eye-opening to me, though, was that the teachers' unions opposed all three of Bennett's C's, content and character, too. And in truth, our emphasis on a traditional core curriculum and on a belief in right and wrong and absolute moral truth versus equivocal moral relativism, those priorities were to some extent a direct pushback on the influence of the National Education Association. What surprised me most was the extent to which the NEA spent time and resources on issues that weren't about education at all. A nuclear freeze, the Equal Rights Amendment, opposing nuclear power plants, opposing the Nicaragua Contras, opposing Robert Bork. The NEA was spending teachers' dues on political issues that weren't about education and that sometimes conflicted with many of their members' own views. Of course, the positions that I saw being taken by teachers' unions were often against the interests of students, too, as in the case of the Third C. This conflict with students' interests was something I was to see again firsthand as Secretary of Labor. Just to skip ahead to that for a moment, in the summer of 2020, the country was reopening from COVID and the COVID shutdowns. Workers had been returning to the job since May. Just months before, in February, the unemployment rate had been 3.5%. Then came COVID, and in April, 2 months later, unemployment was at 14.7%. So in early June, when I opened the job report for May, it was with complete trepidation. How much higher had unemployment gone? Predictions were that we would lose another 1.5 million jobs just in May. Well, it turned out we had added 2.5 million jobs in May. A 4 million jobs swing over expectations. An historic economic rebound had begun, and in June, the nation added 5 million jobs in that month alone. Starting in May, again, 2020, I started visiting workplaces again, which is a staple when you're labor secretary. The idea for these trips was to talk about how we were reopening the economy, but as I traveled, I was quickly reminded how many Americans had never left the workplace. My white-collar friends had. They wouldn't return for another year, or longer, or never. But in manufacturing and retail, a work site might have closed 2 or 3 days to figure out how to incorporate COVID protocols. But they were open, they were working, and mostly, they were working safely. Restaurants were desperate to reopen, so was hospitality. A major part of what we were doing at the education department, or the labor department during this time, was helping workers and employers understand how to work safely during COVID and to take action when workplaces were unsafe. But again, by June 2020, and certainly by early July, we knew in workplaces throughout the country that it was possible to work safely through COVID. I saw schools at this time, in a way, a bit like teachers did, as workplaces. Teaching is a job. It's many other very important things, but it's a job too. And I knew to a certainty that like other workplaces, we could open schools safely in fall 2020. The country had decided months earlier that workers in manufacturing were essential. Retail workers, we said, were essential. Agriculture, essential workers. Well, my view was simple. Teachers were essential workers too. They are. How could we think otherwise? We knew that the threat in the school setting was no greater than in retail or manufacturing. And we knew that the COVID risk to young people, students, was especially low. In fall of 2020, schools across the country did indeed open safely. My son went to college back at Denison University in Ohio. My daughter resumed classes at Furman University in South Carolina. My youngest son, this list goes on, I have a lot of kids. My youngest son went back to his private middle school in Maryland. And my two youngest daughters returned to elementary school, but only because I moved them to a private school out of their public schools in Fairfax County, Virginia. Those schools didn't bring students back until about March 2021. I think even then it was halting. The decisions that states and school districts made about reopening in fall 2020 deserves meticulous and objective scrutiny and study. Jurisdictions across the country faced similar circumstances and made radically different decisions. Those decisions had huge consequences. The consequences should be documented. Responsibility for the decisions should be assigned, and the error that was made should never be forgotten. I hope someone is funding the research. Just a comment on that. I mentioned, I was in the Reagan administration, and one of the things that we talked about at that time was the superiority of our political system and American virtues to the Soviet Union. And we had opponents. We got grief for that, including from people who are in the Senate. It was controversial to espouse those views. But I don't know that the people who are on the wrong side of that seismic historical debate have ever been held to account for the errors they made in suggesting that we should treat ourselves as more equivalent to the Soviet Union. And this, I think, is another instance where there were stark choices and radically different decisions and mistakes were made. And it's something we should all remember. Let me assure you, from the perspective of workplace safety, let me assure you the refusal to reopen schools in fall 2020 was indefensible. After 2 years working for Bill Bennett at the Education Department, I left for law school and I began practicing labor and employment law. I now saw a very different side, a positive side of the labor movement. I was a lawyer for companies whose workers were represented by labor unions. It's one of the things I did. And I saw union business agents who were focused not on ideological battles, but on representing their members, keeping them in their jobs, or getting them back to work, or negotiating for higher wages, or for more generous leave policies. Often I found these union reps, as we would call them, they knew the workplace better and knew better what their union members needed than government officials responsible for administering federal employment laws, such as at the Labor Department or the Equal Employment Opportunity Commission. These were boots on the ground, local union leaders who knew the workers and their faults, and who knew the job and the company's managers and their faults. Definitely, there were acrimonious moments. At times, the unions took unreasonable positions. At times, the companies did. But what I saw in these private sector relationships, more often than not, was people acting in good faith. In many ways, I thought it was a better way for managing the workplace than the highly litigious, highly regulated environment fostered by our federal employment statutes. And so, in the year 2020, right before the presidential election, I wrote a law review article for the Federal Society, the Harvard Journal, proposing an approach that I thought could reinvigorate the private sector labor movement while also reducing unnecessary regulation of American businesses. What I asked was, is it really necessary for a company with a labor union to be subject to precisely the same degree of federal and state employment regulation as a non-union workplace? After all, I argued, many employment laws have the same objective as private sector labor unions: fair wages, a safe and healthful work environment, a measure of job security. And I said, if a company knew that if it accepted a labor union, it could negotiate with the union to be subject to, say, less inspection and oversight by the Labor Department, or could negotiate to be exempt from wage hour class action litigation. If those kinds of deals could be struck, I suggested, maybe some employers would be less resistant to having a union. And I said government regulators could focus on workplaces where there wasn't a union looking out for workers' interests on a daily basis. So I envisioned this article as a bit of an olive branch to the labor movement, as a possible middle ground that might appeal to Democrats and Republicans alike. And I got a favorable reaction from some academics who were sympathetic to the labor movement, and in private, from some labor leaders. But publicly, within a few months, this article was Exhibit A in the attack on my nomination to be the labor solicitor, which is the general counsel, Labor Department, for President George W. Bush. You know, in fairness, it was like B or C. I mean, there were other exhibits, but if this were the law, I was told, if this were the law, here's the first thing that a company would do when it faced a union organizing campaign. They would pick up a big, hefty volume of the federal employment statutes, stand over a burning trash bin, and say to the workers, hey, you form a union? You can kiss those federal employment rights goodbye. I thought that was a pretty good point, to which there are actually very good responses. But given the reception I'd gotten, I saw no point in pursuing this particular proposal. And in the years since, to my knowledge, neither has anybody else. Well, I greatly enjoyed being solicitor at the Labor Department. The office had many good and dedicated career lawyers at the time. We got a lot done. One momentous event we confronted was the dispute that shut down the West Coast ports in 2002. I cautioned against quick federal intervention in that labor dispute. Economic pressure is what ends strikes and lockouts. And I believed we should only relieve that economic pressure when the entire nation's well-being plainly demanded it. As solicitor, I started to deal with an employment statute that I hadn't encountered in private practice, and that was the Landrum-Griffin Act, or the LMRDA. It gives union members certain rights with respect to their union, and it's administered by OLMS. That's a Labor Department agency also responsible for investigating union corruption and making criminal referrals to the Department of Justice. OLMS is a bit of a red-headed stepchild at the department. Under Democrats, it's severely underfunded. Republicans support it financially, but at times hesitate to talk about its mission. But there's no reason for that. If you support unions and union workers, then you should oppose corruption that robs both the union and the worker. As secretary, I spoke proudly of the achievements of OLMS, like its role investigating the corrupt, now former leadership, very top leadership of the United Auto Workers. And I felt bad when I halted OLMS's proposed rule to subject some additional public sector unions to federal reporting requirements. I felt bad because OLMS often finds itself stymied by the department's leadership, and I thought some good could come from that proposed rule. But I didn't feel that we had justified the cost we'd be imposing on those additional unions, and ultimately the cost that we'd be imposing on the members who were paying the dues. So we didn't go forward. Back when I was solicitor, I had a project to identify enforcement agencies at the department that had what I called high hit rates. And by hit rate, I meant success in finding a violation when you conduct an inspection or investigation. I was interested why those agencies with those high rates were more successful than other agencies in finding violations, and what other agencies could learn from that. An agency that opens a lot of investigations that lead nowhere is wasting public resources and unfairly burdening law-abiding companies and unions. Well, I found that OLMS had a very, very high hit rate. It had an average of more than 75 criminal convictions a year for the 10-year period 2013 to 2022, for example. I don't point this out to criticize unions. I point it out to defend OLMS, its mission, and their work on behalf of unions and the workers who belong to those unions against people who would prey on them. That conviction rate deserves more attention and respect, because when OLMS funding is cut, its ability to fight that corruption is cut. That said, I do want to call out one union. There's data showing that the American Federation of Government Employees, AFGE, has the second highest number of criminal convictions among all labor unions. This is the union of federal workers. Why are our federal employees represented by a union with such a corruption problem? It's a question that ought to be asked, and which the national leadership of the AFGE ought to answer. If you ran a national corporation with multiple subsidiaries whose officers were convicted you wouldn't tell the public, and you wouldn't tell Congress, oh yeah, no, I'm the national CEO. Those are just like my subordinate subsidiary guys. Likewise, when a national union has a problem with convictions among its affiliates, it should take responsibility for that. Ultimately, it should be held responsible for that. Well, the article that I wrote years ago about unionization and federal regulation had a premise. That was that unions' importance in the private sector workplace was in decline. In 1956, private sector unionization was 38%. When I wrote that article in 2000, it was 9.4%. Today, it is 6%. Yet even as unions' role in the private sector has waned, my experience as labor solicitor nominee illustrated their abiding power in another respect, politically. My nomination was voted out of committee, but Tom Daschle, the Senate Majority Leader, refused to allow me a floor vote. I will never forget watching him on national television one Sunday morning lying about the reason why. I took a recess appointment. Among some conservative commentators these days, there's a vogue for labor unions. We support we support workers, their thinking goes, and we therefore support labor unions. Now, I've been clear, labor unions can do very good things. But some of these commentators have little, if any, actual experience with the labor movement. And they'll have a hard time making Republicans the party of labor, so long as those unions' national headquarters devote so much money and time to supporting Democrats and unrelated progressive causes. The role of labor unions in the political sphere, particularly the role of public sector unions, I know is a focus of this conference today, and it's a subject well worth examining. I want to wrap up by talking about unions' role in another sphere, and that's our financial system. Years ago, when he headed the mine workers union, before leading the AFL-CIO, Richard Trumka said that unions had to learn, quote, to organize our money essentially the same way we organize workers. They had to organize our money the way we organize workers. What he said was a crucial insight for the labor movement, but also for me to hear that and think about it. It was a crucial insight also for those who follow the labor movement. I more fully appreciated what he was talking about when I returned to my law practice after being labor solicitor. Colleagues of mine at my firm who advised corporations on shareholder relations were often fielding issues being raised by labor unions on behalf of the pension plans the unions sponsored jointly with the companies they had organized. I learned that as pension plan trustees, these unions had clout in corporate boardrooms and at the Securities and Exchange Commission. By the way, Karl Marx would have been horrified labor had become capital. You can actually argue that today unions have more influence on corporations as shareholders, that is, as pension plan trustees, than they do as representatives of corporations' workers. This influence resulted in an SEC rule that I later challenged in the DC Circuit Court of Appeals. It was called the proxy access rule. It enabled certain large shareholders to use the company's proxy to put forward their own dissident candidate for the board of directors without having to conduct a full-blown proxy contest. Doing a proxy solicitation is costly. Dissident shareholders have to fund and distribute their own materials. This rule would essentially let them free ride on the company's proxy. Well, this rule had a number of problems, including we argued that it violated the First Amendment. In the lawsuit, one issue we focused on was which shareholders the rule would empower. We showed that the shareholders with large enough investments to qualify for the rule and who had the inclination to use it were predominantly pension funds, private sector union funds, and giant public sector funds like CalPERS and CalSTRS. These union and government funds were the rule's most ardent proponents and had exercised outsized influence in getting the SEC to adopt the rule. I loved it, by the way, when they filed an amicus brief. against me. I think it was the only amicus brief in support of the SEC. It was all these gigantic union pension funds, and I was able to say to the court, see, I told you. In court, we defeated the rule partly on this basis. The commission had arbitrarily assumed that union pension funds and government funds would act in a way that furthered the interests of shareholders in general. But we had submitted evidence showing that private sector union funds sometimes used their investment muscle, for example, to promote union organizing. There was a literature out there that I found urging union funds to use their investment influence to pressure companies to stay neutral during organizing campaigns, for example. As for public sector union funds, they also sometimes act to support union organizing by their friends in the private sector. And they're also often led by political figures who pursue political goals that your typical shareholder is not interested in. The DC Circuit ruled that the SEC had erred in assuming that these large shareholders would use the proxy access mechanism for purposes that benefit shareholders generally. They threw the rule out. There's been a lot of attention recently to this issue, to the ways in which investors and money managers use the financial system to pursue non-financial goals. I adopted a rule on the topic as Labor Secretary. It had a simple point. Under ERISA, retirement plan fiduciaries must manage plan assets for the exclusive purpose of maximizing returns to provide for the retirement of plan participants. There are trillions of dollars in ERISA plans, and that money is not to be harnessed to pursue other goals, however worthy they may be. To my knowledge, the rule we adopted was the first federal or state rule on so-called ESG investing. In adopting it, we were clear that there are times that environmental considerations or considerations of corporate governance, which is the G in ESG, there are times when those are appropriate or even necessary under ERISA. You don't invest a retirement fund in a Superfund site without taking account of the potential liabilities. My concern, though, was the growing interest some people have in using the resources and influence of the financial system to push policy goals like addressing climate change. I didn't want ERISA fiduciaries diverted in that way. As I said at the time, ERISA plans further one incredibly important S, social. They further one incredibly important S goal, retirement security for American workers. That shouldn't be compromised. Well, last year, the current administration replaced my rule with one that's intended to be more favorable to ESG investing, and that rule is in litigation. Whatever the outcome, there's one thing the new rule can't do. It can't change the constraints that Congress itself imposed through ERISA on pension plans. Something my ESG rule didn't address was the activism of government pension funds, because those funds, the ones run by state and local governments, are exempt from ERISA. At times it might seem they're not governed by any law at all. They run deficits that would never be tolerated under ERISA. Sadly, that's a reflection of a bargain in some jurisdictions where government unions elect politicians who repay the favor with benefit promises so lavish that someday taxpayers will be asked to make up the shortfall. The truth, though, is that state and local government pension funds do operate under legal restrictions, including, in most places, the same fiduciary responsibilities that animated my Labor Department ESG rule. Let me give you some quotes. A fiduciary, quote, owes a duty of undivided loyalty. This requires plan managers to, quote, single-mindedly pursue the interests of those to whom the duty is owed, namely retirees and plan beneficiaries. Plan trustees are to act with the, quote, exclusive purpose of providing benefits to those people. Courts should enforce this, quote, strict standard with uncompromising rigidity so as to not, quote, undermine the rule of undivided loyalty. There's also a duty of care under which pension managers are to, quote, exercise such diligence and prudence in the care and management of the fund as prudent men of discretion and intelligence in such matters employ in their own like affairs, end quote. Well, these phrases, I mean, they could come right out of the ERISA case law. They very crisply summarize obligations under ERISA, but they're actually a statement of the common law fiduciary duties of trustees for government pension funds in New York. Similar duties apply in many other states. A violation of these duties is at the heart of a lawsuit I brought earlier this year on behalf of participants in 3 New York City pension plans. The defendants there include the teachers' retirement system of the City of New York and the education retirement system of the City of New York, and my clients include former teachers and school administrators. Over the last few years, these 2 New York City plans and one other plan have divested their oil and gas related holdings. $4 billion in oil and gas related divestments. This was put in motion by former Mayor de Blasio. He announced the initiative standing in front of course, a green sign that said New York City was leading the fight against climate change. When he put this initiative forward, de Blasio, he didn't put forward a financial analysis indicating that wholesale divestment of fossil fuel would be in the interests of the participants and retirees in the city's plans. Instead, he said things like, quote, "Our first in the nation divestment is literally putting money where our mouth is when it comes to climate change." A trustee of one of the plans said, quote, "I'm proud to cast my vote for a more sustainable portfolio and healthier planet. Divesting from fossil fuels is a move that has been long in coming. It is a reflection of our pension trustees' collective commitment to what? Environmental responsibility," and so on. But what was terrific about this is that 3 New York City pension funds signed on to the mayor's initiative. But 2 funds said, no, we're not going to do that. The police and the firefighters. They blew the whistle. These trustees attended the same meetings as the other trustees, heard the same presentations, and recognized the divestment proposals for what they were. So let me quote Pat Lynch, who headed the police union until recently. Quote, "Every pension fund trustee has a fiduciary responsibility to act in the best interest of the fund beneficiaries for the exclusive purpose of providing benefits. The money in the pension fund does not belong to us, nor to the comptroller, nor to the mayor. It belongs to the active and retired police officers who have worked and sacrificed to earn their pensions. Our views on any social or political issue cannot enter into the equation." It's great. Andrew Ansbro, head of the firefighters union, he said, quote, "We have not entertained that idea of divesting from fossil fuels. We do not see our pension fund as an object to be used to make political statements. Our job is to provide for our retirees," end quote. The divestments by the 3 other funds, which started in 2021, were made at a time when energy stocks were some of the best that you could hold. In 2022, the S&P 500 energy sector was up almost 60%. It was the only segment of the S&P 500 index that in 2022 didn't have a loss. And in the prior year, 2021, the energy sector index was up almost 50%, again outpacing the broader S&P. Yet those 3 plans continued their divestments anyway, and to this day continue to base investment decisions not simply on delivering returns for investors, for retirees, but on making statements about climate change. Our case is in early stages. I hope others will take note of it. Plan trustees in other states and cities who may be considering similar actions, and the participants in such plans who typically are owed the same duties as my clients in New York City. Providing a secure retirement is a laudable goal and a weighty responsibility. Government officials should focus on that responsibility and not treat retirement funds as their own personal war chest to wage other policy battles. Because with all respect, and contrary to former President Trumka, it is not, quote, our money, quote. Well, it's been a pleasure to share these thoughts with all of you today about the workforce, the labor movement, and somewhat about education. Thank you again for having me here, and I'd be pleased to take questions.
Yeah, Gene.
Yeah, I've
I'm sure other people have read that, but we don't know what's propaganda and what's real.
I think there is some data indicating that the union election rate has been higher in the last, year or so, something along those lines. But this is at least the third time since I started practicing law that I read breathless press in the national media and in the trade press for employment lawyers about a surge in unionization. And neither of the prior two times did that surge ever actually materialize, make a difference. At the end of every year, you would look at the report from the Bureau of Labor Statistics on the union density rate in the private sector, and it would be down again. So we'll see. There's certainly enthusiasm in certain quarters. And we'll see what happens in Detroit over the next few days. And workers have been in a strong position since the economic surge that began under President Trump. And then that was, of course, accelerated in some ways by COVID. And I think that might have resulted in an increased sense of power on the part of labor unions. But I do not think that we'll be looking back 3 years from now and say, wow, things changed, now unions in the private sector are on the rise again. As I think all of you know, the other side of that story is that in the public sector, unionization has grown in leaps and bounds. I'm not sure what the trajectory has been in the last 10 years, but over the last 40, 50 years, that's been the great change. And that's where a lot of the energy in the labor movement is now. It's in the public sector unions. Yeah, there's a question there. Oh, hi. It's a great question. I think everybody heard of it. The question was sort of generally concerned with, are we sending too many people to college? Professor thinks we are. I agree. Okay. Not too many to law school, just college. And so, very good. And so, how can we enable more people to go into the trades without necessarily going through college? And it really is an important question. I cut out a little part of the speech that I had that I'll now deliver, which is, what are our colleges doing anyway? When I worked for Bill Bennett, the idea was that we had this incredible cultural heritage and shared set of ideas that we needed to transmit in order to make people educated, cultivated, productive, patriotic Americans. There's no such consensus anymore. On the contrary, our humanities departments have, in my judgment, basically put themselves out of business by spending the last 50 years saying that our great cultural heritage is actually racist, sexist, oppressive in all kinds of ways. So fine, I won't bother. I guess I don't have to read Homer. And so, what do our colleges claim to be transmitting now? So that's a separate question. But actually not entirely in jest. I do think that partly because colleges have in some ways torn themselves down, attacked their own mission, their own value, people are saying, yeah, fine. If you think your product is really that oppressive, then I'll find something else to do with my time. And I think that's one reason you are seeing, particularly among young men, less interest in college lately. One of the things that was so extraordinary in that economic boom that we had pre-COVID in the Trump administration was that employers were so desperate for workers that they were doing more to provide the training. They became more interested in apprenticeships. They became more interested in hiring people who historically had challenges and faced discrimination in the workplace because they just needed workers. So I think it wasn't entirely coincidental that unemployment rates for blacks and women, for example, were at all-time recorded lows during that period. There was a shortage of workers, and companies were stepping forward and doing some things that schools were failing to do. And I think because the worker shortage has continued, those efforts have continued. I mentioned that apprenticeships were largely a bipartisan matter. Unfortunately, we did adopt an apprenticeship program at the Labor Department that my successor quickly dismantled. It was opposed by the labor unions because it enabled you to participate in a federally recognized apprenticeship program, effectively federally recognized program, without going through all the requirements of the Labor Department's apprenticeship program. The trade unions dominated the Labor Department apprenticeship program. They didn't want these other alternatives out there. And so under my successor, unfortunately, that rule was done away with. It's really, I think, unfortunate and indefensible. This was just just another way of making it easier for companies to work in conjunction with community colleges, for example, in offering apprenticeships. So sort of a long answer, but good question. There is, I think, strong bipartisan consensus that we've been valuing college too much, sending too many people there, and not assisting enough and respecting enough the people that want to pursue a different path. And the paths aren't exclusive, which was my point about the control at that Michigan company. Go to work right out of high school, and if you decide you want to go to college, and now you know what you want to study and why you need it, then go do it. I'm sorry, question here and then there, because I know your hand was up earlier. The question was whether I took a position on apartheid divestment as labor secretary, and I didn't. So, question back there? Yes.
By doing at the request of the parents as an alternative to what formal education they might get in a public school or elsewhere. Could you envision that happening?
I mean, for centuries and still today, people learn a job while working alongside a parent. And many go on to have very successful careers in that same field. I don't know that you need necessarily an apprenticeship program to honor that. If what you're describing is a situation where a young person is taken out of, let's say, the junior year of high school in order to work at home in a form of apprenticeship, I think I'd probably be a little bit careful about that, actually, because I do think that there are many benefits that come with at least a high school education that we should be careful about sacrificing. But interesting idea. I've not seen it proposed. Yes.
I'm really interested in the shareholders' rights and ESG angle. Could you give us a little bit more color about the firefighters and police case? I assume you're in state court. Are you trying to overturn or argue against the validity of the mayor's order, or just preserve the ability of the individual trustees for the police to make their own decision, was an injunction granted against the divestment, and any lower court rulings now of interest?
Yeah, we filed our lawsuit in May. The pension funds have moved to dismiss the case on a few grounds, but importantly, they've not denied that they owe these fiduciary duties, which we've described. So we're now briefing that motion to dismiss. And in terms of the relief we seek, my clients want the pension funds administered for the exclusive purpose of providing for people's retirement benefits. They don't want these large pots of money being treated as a weapon that can be deployed by city politicians, city union leaders to pursue other objectives that hold more interest for them than managing the funds. And so we want an injunction going forward, but there also have been losses to the plans that have resulted from those divestments, and those ought to be made whole as well. Oh, by the way, there are other cities that have considered this, and some have refused to do it. There are actually memos that were written by the lawyers for, I believe it was Seattle's pension plans, in which the lawyers said, don't do this. It would break the law. It would be a fiduciary breach. And there was a similar debate, we know, in the city of San Francisco about some things that it considered. Question here? So I'm sorry, the question is, how can the Republican Party effectively support increased manufacturing? Yeah, well, I think that President Trump, for example, pushed that hard, really championed it, and had Republican support. I had a piece in the Wall Street Journal a couple Labor Days ago where I described a conversation I had with a very senior labor leader, where I said to him, you and your members must be thrilled with the Trump administration because it's been so good for workers. And he looked at me like I was crazy, and he quickly ticked off a lot of rules from my agency and others that he didn't like, and some decisions by the National Labor Relations Board. And of course, what I was talking about was the jobs and the wages, which meant increased retirement benefits and all of the great things that were actually happening to workers on the job. And he, as a DC labor leader, was just focused on the DC policies rather than the impacts. And so, again, that economic surge, the Trump administration, worked wonders for manufacturing among other sectors. The U.S.-Mexico-Canada agreement was a really important trade deal. You'll remember that one of the bases on which President Trump ran was to undo NAFTA because he thought it was a bad deal for American workers. And one of the chief aims of that treaty was to, among other things, assure that American workers were not going to be experiencing such direct competition from workers so close on our border who had nothing like the employment rights that we like. And that was intended in part to help American manufacturing. This gets to be a difficult area, industrial policy, but particularly after COVID, but even before, I was a believer that we have a national interest in the vitality of our manufacturing sector, and it's something that we need to look after. We need to place great trust in the free market and be very careful about second-guessing the free market. But I think we can't be indifferent to the need for a vibrant manufacturing sector, is one example. And again, I think there's actually bipartisan consensus on that. Yeah.
think we could all agree that more apprenticeships are necessary in order to satisfy the needs of the 21st century labor force. But I think we also need to recognize that in many of the technical schools and places that train apprentices have horrible graduation rates and tend to load up graduates with massive amounts of debt. And I'm wondering how you think we should respond to this issue.
Yeah. One of the most dismaying things that I saw at the Labor Department was how little reason we had to believe that the billions of dollars the department spends every year on worker training programs were having any positive impact. The Labor Department's budget, I'm a little rusty, I think it might have been about $15 billion, about 12 of which was for worker training. Mostly it was money that went to the states to then run their programs. And when you could find data on whether those programs were working, the data showed they weren't. But it was hard actually even to find data. And something that we were working on was extracting the data and then putting it in the hands of the people who received the state funds. You know, you get some state benefit to go get training, but right now you don't have a list of providers where you can look and see how they actually perform. What's the graduation rate? What's the employment rate? What's the employment duration? And is it in the job that you trained for or some other job? And that kind of basic information is not available. It was really dismaying. Call me naive. I was new to that aspect of federal bureaucracy, but we're spending billions of dollars with very little information on whether it's working. So that's where you need to start, and it's something we worked on, but you need to start by getting better data on how these programs perform, putting that in the hands of people who make the selections, and when people aren't performing, cut them off. Yes.
Labor explosion. Where are they now? I mean, I've not heard any really good explanation. Everywhere you go, there are people. I think the service industry in particular is suffering because of that. So what happened to those folks? Did they leave the country, or I don't know. Everybody can't be on the dole.
What happened to those workers?
Yeah, where did they go?
That's still being examined. I think the data in the last jobs report for August showed that the labor participation rate, particularly among young people, is actually starting to come up. But labor participation, especially among young men, has been a problem for a long time now. It got worse, and not just for young men during COVID. Obviously, we've heard that during COVID, some people just reappraised their lifestyles, what they're prioritizing, and checked out of work a little bit. A positive development, the Wall Street Journal had a terrific story maybe 6 months into COVID about all the people who had started their own businesses. For example, you were a trainer at a gym, the gym shut down, you started your own training business. So there was a lot of that going on. The unemployment benefits we provided under the CARES Act unfortunately proved to be much too high, and then those benefits were extended for far longer than could be justified, and I am certain that people banked away a lot of those benefits, and that kept some people out of the workforce for a long time too. Dean, I think I should wrap it up there. Okay, well, thank you again for having me, and thank you for all the work that you do.